Good morning, everyone, and welcome back to Cover Talk, Mills Reeve's series of 15-minute webinars focusing on key insurance and reinsurance topics. My name is Andrew Tobin, and I specialise in insurance and reinsurance coverage disputes. I'm a partner at Mills Reeve's London office. Today, we'll be looking at causation in insurance policies. If you have questions as I go along, please do type them into the question and answer box, and I will try to deal with them in the second part of this session, or follow up with you directly afterwards. It's a short presentation, and so I won't be using any slides today. So we're going to look at why causation is important at all, the general rule known as the Doctrine of Proximate Causation, with 2 or 3 examples, what happens where there is more than one proximate cause, one of which is excluded, and finally, we'll look at how variations in wordings can change how the usual rules apply. I want to emphasize at the outset, though, that although there are a number of important principles around causation and a lot of case law, English judges purposely seem to have baked a certain amount of imprecision into the rules they have developed. An advantage of that imprecision is that it allows the courts some flexibility and discretion to achieve what they feel is the right result in particular cases. But on the other hand, it can lead to reasonable disagreement between insureds, insurers, and their lawyers as to what caused losses in particular cases. That can lead to disputes, and disputes lead to litigation. So probably causation is one of the most hotly contested disputes in insurance law or in insurance practice. But why is causation important at all? At the risk of stating the obvious, causation is important because insurance policies do not cover insureds against any kind of loss. Rather, they are framed so as to provide cover only for particular types of loss or damage. As a first step to proving an insurance claim, an insured will always need to prove that it has suffered loss and that that loss was caused by one or more of the perils covered by the policy, and not by something else that was either not covered at all or by something that was excluded. Firstly, let's consider named perils policies. That is to say, policies that specifically list only the perils insured by the policy. So, for example, if the policy covers only fire, the insured must prove that a fire caused its loss. In a political violence policy covering terrorism, then an insured must prove that terrorism caused its loss and not something that was not insured, such as a storm, for example. Or in a professional indemnity policy, the insured must prove that its loss was caused by a claim made against it that arises out of the performance of its professional services. Causation is also important in all risks policies. All risks policies do not specify particular perils in the coverage language, but they always require the insured to prove that its loss was caused by a sudden, accidental, and unforeseen event that occurred within the policy period. So, whether we're looking at all risk or named perils policies, the insured is always going to need to prove that its loss was caused by a peril in the coverage language. Then we come to exclusions. Most policies contain a long list of them. Even if a particular loss comes within the coverage language of the policy, a claim may still be declined by an insurer because the loss was caused by an excluded peril. And if an insurer wishes to rely on an exclusion, then it is usually for the insurer to prove that the excluded peril caused the loss. And later, I'll look at how the courts deal with a situation where there is a mixture of covered perils and excluded perils operating. There are 2 parts to proving causation in an insurance dispute. Firstly, an insured must prove that the insured peril caused it to suffer loss as a matter of fact. If there is no factual causation, then there can be no legal one. Conceptually, that's easy to understand. One simply asks, would the loss have occurred but for the occurrence of the insured peril or not? If the loss would have happened in the same way anyway, then the peril being relied upon by the insured cannot have caused the loss as a matter of fact. End of the claim. In a dispute, the judge will often be asked to decide what actually occurred as a matter of fact. Sometimes that would be easy, but often it can be very complicated and involve the court considering expert, scientific, or other evidence. But whatever the facts are, the legal problem then is that the factual chain of causation can stretch back a long way. Everything has a cause, and those causes themselves have causes. Obviously, in an insurance policy, the parties probably would never have intended that remote factors should be relevant to their insurance coverage in the normal type of insurance policy. But the question is, where does one draw the line? So, for example, in one 1874 case, the judge found the following facts. The ship perished because she went ashore on the coast of Yorkshire. The cause of her going ashore was partly because it was thick weather, and partly because she was unmanageable because full of water. The cause of that cause was when she laboured in the sea, she took on water. And the cause of her taking on water was that when she left London, she was not in as strong and staunch a state as she ought to have been. So there were at least 5 potential causes arising out of the facts. But the problem the courts face is how to identify which cause or causes the loss can be attributed to as a matter of law. The method that the courts have devised or developed to deal with this issue is the so-called proximate cause rule, which was codified in section 55(1) of the Marine Insurance Act 1906, which says, unless the policy otherwise provides, the insurer is liable for any loss proximately caused by a peril insured against, but he is not liable for any loss which is not proximately caused by a peril. That's easy to say, but it's not that helpful because it still begs the question of what exactly is a proximate cause. Amazingly, you might think, there is still not a unanimously agreed single definition of English law of what a proximate cause is that could be applied in all cases. We do know from the English cases that a proximate cause does not necessarily mean the sole clause, the first cause, or the last cause, although it could turn out to be any one of those. Rather, it has been described as the direct cause, the efficient cause, the effective cause, or the determining cause. Christopher Butcher QC has written a textbook in which he says that the most frequently used and a helpful description of the proximate cause test is that it means the dominant cause. And Christopher Butcher is now the judge in the COVID-19 business interruption test cases, so his view will be important. Okay, so now we know that the proximate cause really means the dominant cause. How do you determine which cause is the dominant cause when there might be several causes in a chain of causation and or operating in parallel? Again, in Christopher Butcher's words, the approach to be adopted is, quote, that of common sense. The court does not approach the matter as a metaphysician or a scientist would, but as an ordinary businessman of common sense. The question has been said to be really a matter for the common sense and intelligence of the ordinary man. So, to sum up, the proximate cause does not necessarily mean the sole cause, the first cause, or the last cause. Rather, it means the dominant cause. And the dominant cause can be determined by applying common sense. English courts seem unwilling or unable to be much more precise than that. Of course, the next problem is that reasonable people can often disagree about what a common sense answer to a problem is, particularly where a lot of money is involved. A common issue is identifying the proximate cause out of a number of causes in a chain of events. But to give some examples from the cases where a fire causes an explosion or causes a building to fall, the damage caused by the explosion or fall has been held to be caused by the fire. In other cases where a fire had started causing property to be thrown into the sea, then the water damaged goods were held to held to have been damaged by the peril of fire. In cases where loss or damage is the necessary consequence of the peril insured against, then usually the damage will be held to have been approximately caused by that particular peril. So, for example, in one case concerned a ship carrying a cargo of live animals. It was caught in a storm for several weeks. The animals were injured and most of them eventually died. The policy covered perils of the sea, but excluded the mortality of the animals. The court held that the proximate cause in that case was in fact the peril of the sea. The deaths of the animals was the necessary consequence of the perils of the sea that they had been subjected to. It's not usually sufficient for the peril insured merely to have facilitated the loss. It must have caused it. So where goods were stolen from property in an air raid, it was held that the theft, not the air raid, was the proximate cause of loss. Usually, a proximate cause is one that is close in time and space to the damage suffered. But again, there is no absolute rule about that. It's a question of applying common sense to the overall picture. But if proximate cause boils down to common sense, I thought I might ask you to be the judge and decide what the common sense outcome would be in a particular case, using the facts from a leading case. In the case of Leyland Shipping, a vessel was hit by a torpedo from a German submarine in 1915. It was 25 miles away from port. It was able to get into port that same day, but the authorities then ordered it out of the harbour because they were worried it would sink and block it. The ship was towed to an exposed position where it was battered by the sea and where it broke up 2 days later. Obviously, both the torpedo and the action of the sea caused the loss of the vessel as a matter of fact. But the question for the court was which one was the proximate cause. I'll just ask my colleague Leanne to show the poll, but please can you use it to indicate if you think the proximate cause was the action of the sea or of the torpedo. Okay, well, thank you. We have 111 votes. And the result is that 84% of you think the proximate cause was the torpedo, and 75% of you think the proximate cause was the torpedo, and 25% believe it was the sea. Well, in that case, the vessel owners argued that the proximate cause of loss was the battering of the sea, because that was the last event. The House of Lords, however, said that that was the wrong approach and that the proximate cause was in fact the damage of the torpedo. So the majority of you, using your common sense, thought it was damaged by the torpedo, but I think the fact that 25% of you came to a different view shows that common sense does not always lead everybody to reach the same answer to questions. And that's always going to lead to a degree of uncertainty when cases are litigated or disputed. Now, I've nearly used up all my time, but I'd like briefly to make two very important points. The first question is, what happens when there are two proximate causes? And that is to say, when both causes were factually relevant to the loss, but neither one is dominant over the other. That is to say, there were two causes that were operating in combination with each other to cause the loss. But one of them is covered and the other is excluded. In English law, the very clear answer is that the whole loss is excluded. The leading case on this is Wayne Tank, which concerned a fire loss which was caused by a combination of the negligent installation of the goods, and the negligence was a covered peril, and the use of defective pipes, which were excluded under the policy. The Court of Appeal said that in that situation, the exclusion would prevail and the whole loss is excluded. Now, this is a very important point and one that I find is frequently overlooked when claims are handled, but obviously it can be a very valuable defence for insurers to take. I would say in passing that claims handlers can be forgiven for finding that outcome surprising because the US courts take precisely the opposite approach. The final point I'd like to make is that the parties are free also not to use the proximate cause rule in their policies if they wish. So, for example, if insurers wish to widen the scope and effectiveness of policy exclusions, they can say that they won't cover losses that are indirectly caused by the peril they wish to exclude. The courts have repeatedly said that where a policy excludes losses indirectly caused by a peril, then one can look much wider in space and time for a relevant excluded peril. That point most often arises in the context of exclusions for war risks and political violence. And one striking case, for example, concerned a life insurance policy taken out by an army officer during the First World War. That policy excluded death or injury directly or indirectly due to the war. The officer was not killed in action, but was killed by a train whilst inspecting sentry posts, and his family made a claim under the life policy. However, his claim was rejected by the court because it was found that his death was indirectly caused by the war, because he was in fact carrying out his military duties when he was hit by the train. So it's a very harsh result, but does show the dramatic difference that a couple of letters can make to a coverage determination. The difference between direct and indirect can make a dramatic difference. Well, I think that concludes my presentation today. We do have time for some questions, so please do enter them into the Q&A box. But equally, if you prefer to contact me directly afterwards with questions or feedback, please do so.
Andrew, do you want to take a couple of questions now?
Yes, please, yeah.
The first one I've got for you is causation relevant in the COVID-19 business interruption cases in the news?
Yes, it's highly relevant. As you may have read, the Financial Conduct Authority is bringing a test case before the High Court. Those cases concern so-called non-damage business interruption policies. And the aim of them is to provide business interruption cover in respect of notifiable diseases or infectious diseases and so on. So one of the questions there is, the matter for the insured to prove is, was their business interruption caused by the outbreak of COVID-19 within 25 miles of their premises or at their premises or whatever their policy wording may say. That's one of the broad, very important central issues in the case. The matter is complicated because a whole range of wordings are being considered by the court. But yes, it's a central point.
It's interesting you make that comment because Sean poses the question, could you please explain the but-for principle or argument, as this would appear to be relevant to the FCA's COVID-19 test case?
Well, it is relevant. So the the insured's, the first stage of the causation analysis is the but-for case. So they are saying, I would not have closed my business but for the COVID-19 crisis. Now they'll probably be able to demonstrate that as a matter of fact, but the question really relates to their difficulty really relates to the second part of the test, which is showing that the factual, that those facts give rise to a sufficiently close connection in law to enable them to recover.
Yeah. And
the insurers are saying, well, there were other things that happened, such as the government ordered or recommended the lockdown, you chose to close your business, and so on.
Yes. Ollie Waterman raises a question. What about the claims involving arson where fire is insured but malicious damage is excluded? How do you think the courts would look at that situation?
Well, that is interesting, particularly as there are two recent Supreme Court cases looking at the meaning of malicious damage. But in a nutshell, what that is likely to mean is that we cover fires as a general proposition, but obviously not all fires are caused maliciously. So we're covering fires caused by accidents or natural phenomenon, but not those that are caused by malicious damage. Malicious damage is a concept used inconsistently in the insurance market. In some cases, it's equated to terrorism. In other cases, it's closer to vandalism. But I think that's the idea. And a similar question does arise often with the political violence cases, where, for example, policies will cover fire or riot losses, but they will exclude losses indirectly caused by, for example, civil commotion or insurrection. So the analysis in that case is, yes, okay, there was a fire, it appears to be covered. Oh, but hang on, there's an exclusion. That fire loss was indirectly caused by the civil commotion, and the analysis then is that the whole loss is excluded. Yeah,
thank you. Alistair Buchanan asks, how severe does a break in the chain have to be to change causation, do you think?
Well, that is a very good question. So there are certainly circumstances where breaks in the chain of causation can interrupt it, and the most common example is willful misconduct by the insured. But there are two ways of looking at that. One, the willful misconduct either breaks the chain of causation, but also he then stops the he will then stop the loss being a fortuitous matter. As to how severe that needs to be, it's rather difficult to articulate, because I think it comes back to that point about common sense and judgment.
Just going back to the COVID-19 point, one of the submissions is COVID-19 will be hard to prove, though. How is it defined that someone caught, say, from a fellow employee and is claiming for personal injury? I think I get the gist of the question. It's not quite straightforward. Basically,
I would ask that questioner to follow up with me afterwards. I think it's conflating possibly some issues from the law of liability and the law of coverage.
Yeah. There are a couple, but they are very long, and perhaps they can be dealt with again through email directly. I think we're running out of time to continue with them.
Okay. Do let us know how we did today. Do let us know what future topics might interest you, and use the question and answer tool. This recording will continue for a couple of more minutes to allow those questions to come in. But please don't forget that next week my colleague Pete Maloney will discuss the burden of proof in insurance policies. And if you have missed any of this series of webinars, they are all available for free online on our website. Just Google Mills and Reeve Cover Talk.